Good morning.
Good morning.
Emery Wood on behalf of Appellate Houston. I would like to reserve 5 minutes for rebuttal. This is a dismissal for fraud on the court case, which understandably the standard is a narrowed abuse of discretion standard, as we point out in the brief. There has to be clear and convincing evidence, and I think this court has said that it has to be blatantly false in a couple of decisions that have occurred. The Ramey versus Haverty case and the Morgan versus Campbell case. Ms. Houston was involved in an automobile accident, a pretty significant automobile accident, ended up having some neck surgery as well as some other injuries that she had from that accident. As was presented to the court at the time of the hearing on the motion to dismiss for fraud on the court, this was not just one where they filed the deposition transcripts and said, do it on the transcripts. Ms. Houston was there. Ms. Houston provided testimony at that hearing in which she pointed out that she'd never had a claim before, she'd never given a deposition before, she was nervous in her deposition, she had a high school education, she felt that she had had a headache problem all her life and that was what she thought her problem was. And as we point out in the brief, one of the critical things that I think that makes this case a little bit different is that she had even said to them that she had had epidural steroids into her neck on one occasion. I think 2 occasions, they'd recommended 3 and she only did 2. Now if you, and we compare this case a little bit to the Bologna case, which the Bologna court points out that it appears to be a little bit of a strategy on the defense to ask these questions in kind of a broad way, having stuff in their hands, not going in specifically to say, well, you know, did you go see Dr. Bushnell Clark? Did you have neck complaints to your primary care physician? Because the records here seem to show that you do.
You had the medical records had been produced before her death.
They had been subpoenaed, yes. And there had been requests for copies, and I believe there was an affidavit filed saying that those requests for copies had not been provided. Now, you know, the deposition could have been canceled, and I think one thing that, you know, it's easy for me to say, I can remember every doctor I've ever seen in my life. I may not remember their names, but I can tell you the name of the dentist that I went to when I was 14 years old in LaGrange, Georgia. But if you talk to the common folk on the street, that may not be what they can do. And we as lawyers generally are considered to have a little bit higher IQ. It takes a little bit more to get into law school.
Well, even if she remembered all the doctors, I mean, the key point I hear you trying to make is, in her mind, she was being treated for headaches, not for neck problems.
Yes. And there certainly are, and there are certainly records that have been pointed out where the doctor said she had neck spasms, she had neck complaints, or neck pain. And she had, and if you look at one of the questions on the interrogatory answer, it was like, have you ever had any neck injury or condition? And then she was asked in her deposition at one time, one of the questions that they relied heavily upon was, can you tell me any other doctors that you've seen? No. Well, you know, it's easy to say in closing argument to a jury that that means she was not being forthright about that, because she should have said there are other doctors. But the question wasn't, are there any other doctors? Now, here are the doctors, here are the 5 doctors you've listed. Is there any other doctor that you've seen anytime in the last 10 years? That question was not asked, and it was not followed up on. But that was what was presented as indicating that there was a blatantly false testimony that was an attempt to thwart discovery on this issue. Now, it certainly is arguments that can be made to a jury, but the point that we're trying to make to this court is that she should have the constitutional right to have a jury of her peers decide whether she was being truthful and whether this pretty significant accident caused neck surgeries to her neck, or if it was just a pre-existing problem that she had and this accident had no effect upon it. But she should have that right, and should be able to present that to the jury. But this is not the type of case that is clear and convincing blatantly false testimony.
Mr. Wood, clearly there are worse cases, and you all have cited to some of them, and there was supplemental authority of a case that was extraordinarily egregious, and there are cases that a plaintiff is not quite as, I don't want to say lack of candor because maybe she didn't remember, but clearly so there are cases that are not as bad as this one. There were the extremes. The difficulty in this case is particularly the one doctor who testifies, I think it may have been Baggerly, who talks about the MRIs and the Vicodin and the Family Medical Leave Act application. His testimony seems to suggest or show a pattern over a course of years where she is getting and complaining of and getting treatment for neck injuries. He also makes some reference to headaches, but he seems to focus pretty heavily on neck pain and neck complaints over a course of years. And so can you address that?
He does. And I can only say to the court that certainly with my years of experience, that I know that what is in the medical records themselves and the comments that the doctors make in the medical records aren't always what the patient is saying to the doctor. The doctor can be in a hurry. There's lots of different reasons, and we've certainly seen that as a jaded, primarily defense attorneys, even as a jaded defense attorney, I can look at records and say, well, these things are computerized, they're formed things, they're saying things, and what one person thinks is a neck problem and an unsophisticated person thinks is a headache problem that's causing spasms into her neck, which is one of the things that she actually said in her testimony. But clearly it's argument, and clearly it would be something that could be presented to a jury for a jury to decide that she had significant neck problems and that this significant accident, didn't cause the need for surgery. But it ought to be a jury decision on that, not a dismissal for fraud on the court is our point.
How does the fact that the trial court conducted an evidentiary hearing and gets to weigh credibility play into this? Because it seems, reading between the lines a little bit, based on her testimony, where at some point she says, oh, now I do remember. I can see a trial judge's reaction being, isn't it convenient, the case is about to get dismissed, now you want to tell me you remember and it was just an accident you forgot.
And the explanation for that before the trial court, which apparently the trial court did not accept, was she said, Dr. Clark is in the same building as my primary care physician is in. And yes, now I remember that I saw Dr. Clark at one point. Now, she saw Dr. Clark one time, and if that is blatantly false testimony by clear and convincing evidence, then there will be a lot of cases that are going to be dismissed because there are people that forget doctors, that don't see someone somewhere, that aren't purposely out there trying to hide all this stuff. I mean, they found this information because she gave them a list of doctors that she had seen, and they subpoenaed those doctors whose records were in there because her primary care physician was in the same facility, Suncoast Medical Center, I believe it was. But yes, Judge Bray was there, but Judge Bray, we asked him to issue his opinion because we felt like that would have to be, specific opinions, and he did. But he never says that he found this testimony to be blatantly false. And I believe this court has said in two of its opinions, in the Morgan and the other one, the Haverty one, I believe it was Haverty, that it has to be that requirement of finding by clear and convincing evidence that the testimony was blatantly false, not conveniently remembering or conveniently forgetting, or you didn't tell us about this doctor, but that it has to be blatantly false.
I'm trying to recall, were you her counsel at the beginning of the case?
No, sir.
I didn't recall that, but typically plaintiffs' lawyers will get from their clients their medical records. They'll gather the medical information beforehand, before everything goes forward. Is there any indication as to how this all came about, that apparently prior counsel either wasn't aware? Was there any explanation? Was this a
there is, it is not in the brief, but there is, I believe, in her deposition testimony, at one point was asked if you've got any records you want to show her. There was also an affidavit that was filed from the paralegal saying there had been a request for copies of the records, but they had not been provided. Those things are in the record. Now, perhaps best practice would be to say, I'm not giving you this deposition until you give me all these records that you have subpoenaed, at least the ones you've subpoenaed so far. You got to give me those records and let me go through those with my client. Perhaps that would be the best practice to do that. It didn't happen in this case, and that was one of the reasons that we filed the affidavit reflecting that it had not happened. Before I do a rebuttal, I would point out that I think in the brief, the appellees have accused her of lying. I would think the court understands in my reply brief. I said I've tried a lot of cases, and I know good and well I can't say that in front of a jury, and I don't think you can say that to this court either. It's not for us to decide and say that someone is or is not lying. We say what the facts are, and then the triers of fact decide those things. Thank you, counsel.
Good morning, Your Honors. My name is Kansas Good, and I represent the Walters in this matter. This is not a case where the plaintiff had a simple oversight of one doctor visit or one complaint. This is a case where there was unequivocal denial of any prior neck complaint, neck pain, neck treatment whatsoever. And if you go to the records for this prior treatment, there is a plethora of treatment over a course of 6 years. Starting in 2004, when she petitioned under the Family Medical Leave Act for leave from work for neck pain. That was recertified in 2005, 2006, 2007. Moving into 2006, she presented to Dr. Baggerly twice for neck pain and stated she was looking down too much at work.
Why is that not all grist for cross-examination?
Well, several reasons why. Number one, there was a whole line of answers from Ms. Houston that was designed to conceal this discovery. She, never gave up the names of Dr. Godoy, Dr. Burns, Dr. Clark. So all that treatment, Dr. Godoy, Dr. Burns were both pain management doctors. Dr. Godoy is the one who did the injections.
Let's assume that she is being less than candid, and the trial court finds it's clear and convincing. But the problem is there's been no factual determination that these pre-existing neck problems are aggravated by what Mr. Wood calls a very bad accident. Why should I cut her off from being able to say, even if I had prior treatment, this accident aggravated my pre-existing condition, and all the things you're telling me about now, that's grist for cross-examination. And it may very well undercut the merit of her case.
But, Your Honor, that's not what the plaintiff stated in her deposition. Again, she stated, I've never had these situations, and she wasn't saying they aggravated my condition. It was absolutely, I never had it before. And I think that is the key difference in those cases. This case is virtually identical to the Morgan case and the Ramey case, in which this court has affirmed. In all of these cases, the court conducted an evidentiary hearing, engaged the credibility of the plaintiff. Specifically in the Ramey case, that plaintiff gave the exact same explanation as Ms. Houston, that, I thought this treatment was for something else. And the trial court similarly rejected that in the Ramey case, as our court did. And even in our...
Remind me, is that a rejection where there's a finding that she is that plaintiff is indeed less than candid?
Our trial court specifically found that she intentionally misrepresented all this prior treatment.
Okay.
And again, the extensive nature of this treatment belies any allegation that she forgot or misunderstood. It was just a year before our subject action that she went and had a second cervical MRI because she was having further changes in her neck pain. Dr. Baggerly referred her to Dr. Clark, a neurosurgeon. He recommended epidural steroid injections and said she doesn't improve, then she's a candidate for the C5-6 anterior discectomy, and that's the very surgery that she had that she's claiming is from our accident. And again, she then went and had a injection with Dr. Godoy. I'd like to address the appellant's assertion that the standard is blatantly false, and that's not the standard. This court has made clear in the Ramey case, the Miller case, Howard, Myrick, the Lash, that the standard for fraud on the court is where it can be demonstrated clearly and convincingly that a party has sentiently set in motion some unconscionable scheme calculated to interfere with the judicial system's ability to impartially and adjudicate a matter by improperly influencing the trier of fact or unfairly hampering the presentation of the opposing party's claim or defense. And that's exactly what Ms. Houston did here. By concealing that extensive prior medical history, she was interfering with the jury's ability to adjudicate those facts. And I'd like to point the court to the McKnight versus...
Let me play devil's advocate for this point. She disclosed Dr. Baggerly's name.
Correct.
And unless someone is totally oblivious to how the system works, by disclosing his name, it's evident the records are going to be revealed.
How she did not disclose, again, Godoy, Burns, and Clark. How the defense found those records were, again, notations, and I believe Burns and Godoy, they had the records in those.
Baggerly's testimony and his records would have clearly indicated, and do clearly indicate, that she had neck problems, and she had complained of neck problems. And my question goes to the fact that either she wasn't a very good liar, wasn't very good at hiding it, or in fact she wasn't trying to hide it because she disclosed Baggerly's name. And so my question goes to, how much discretion does the trial court have to say, when I'm reading all this and I'm hearing all this, I think she made a mistake by disclosing Baggerly. She probably didn't intend to. And he doesn't make findings like that, but maybe that's what was going through the judge's mind, because he ultimately says, I don't believe her. I mean, in not so many words, but in ruling that way. So how do we reconcile all of that?
Well, again, I would point the courts to the Morgan case. In that case, the plaintiff disclosed the chiropractor that she received treatment from. I believe his name was Dr. Merrick. Except she said, I saw Dr. Merrick for preventative scoliosis. And instead, once the defense got those records, it revealed extensive low back and neck treatment, which she said she never received before. And this court found that that was good enough to rise to the clear and convincing. Our case is even more egregious because she did reveal Dr. Baggerly, but she did not reveal Dr. Godoy, Dr. Burns, Dr. Clark. It did take some digging to find that. And so, again, this is a very extensive nature, and if you read her deposition and the hearing testimony that she gave, it is clear she is capable of understanding, capable of answering questions. In the deposition, when she did not know something, she stated, I don't know. But when specifically asked, have you ever had any neck pain before, or have you ever saw a doctor and made neck complaints, she unequivocally said no. And I think that is a big thing, because she never saw any clarification of those questions. She just unequivocally denied it. One other thing I'd like to note, because it has...
She never denied. There's no question that she had headaches.
There is no question that she had headaches. This is all specifically just on the neck pain. But
in her mind, I guess from reading the deposition and the rest of the record, I mean, she's getting this forth this regimen of treatment, but she thinks it is related to her headache condition.
Correct, but if you read her deposition, she describes her headaches differently than she does later. In her deposition, and this is on page 61 of her deposition, she states that her pre-accident headaches were simply above the eyes. There is no mention of tension or pain going down into her neck, nothing like that. It wasn't until at the evidentiary hearing she said, oh, the pain would go down in my neck. And at that point, the trial court simply, rejected this because she saw all these records. I mean, there was, a huge stack, probably about 500 pages submitted to the trial court with depositions and medical records, all rebutting the testimony of the plaintiff here. And again, if you continue in her depo, it says, I only treated with Dr. Baggerly for colds, flu, stomach ache, ear infections, normal stuff. And that was on page 44 of the depo. So even she didn't even state headaches until much later. And in regards to this revealing that she had headaches or had an injection for a headache, this court stated in the Morgan v. Campbell case that revealing only some of the facts does not constitute truthful disclosure. When somebody gives testimony, they're expected to give the truth and the whole truth. And that is something that she just did not give here. And I'd like to circle back to and make one last point on the blatantly false standard. I'd like to point out, too, that the Ramey trial court did not find that that testimony was blatantly false. And again, because that's not the standard that the court looks at. And the Ramey, this court in Ramey, Justice Kennedy wrote that decision, and it appears he was just quoting what the trial court said in Morgan in the decision. And in Morgan, the trial court did say, I found this blatantly false. But again, that is not the standard before this course today.
Mr. Wood raised the issue of some people are more intelligent and more forthcoming than others because they're more intelligent, and some people perhaps are less so. Is there any, and I know at least one of the cases talks about a plaintiff who had some mental deficiencies, and there was some evidence of that. Is this issue addressed at all in the evidentiary hearing?
The testimony was she had a high school education, and that was about it, but there was no evidence presented that she was mentally deficient in any way. And I believe the court is referring to the Simmons case where the plaintiff had an IQ of 65. There was no evidence of that. And if you look back to her depo, she testified that she works at the Pinellas County Clerk of Court's office, and she had to take a test to even qualify to work there. And so she passed that test, obviously, to get that job. So she is capable of understanding, and is a smart lady, to get employed at the clerk's office. And I'd like to just touch base real quick on, there's 3 cases that the plaintiff heavily relies in its brief. The Bologna case, the Gilbert case, and the Gautreaux case. In each of those cases, the trial court did not conduct an evidentiary hearing. And that really is the swinging the factor there, because when there's no evidentiary hearing, there is less deference to the trial court. But here we had an evidentiary hearing, the plaintiff was under oath and testified, the trial court could weigh her credibility. And again, we had a second hearing in this on the motion for rehearing, where the trial court essentially considered it again and then issued a more expansive order. So this is not a case where the trial court, hastily entered something and dismissed something. This trial judge considered this several times and came to the conclusion that Ms. Houston intentionally misrepresented her prior treatment and that it rose to the scheme to defraud the courts. And there was also one point made by the appellant that the medical records can't be accurate or could be not be accurate. That was never brought up in the trial court, so I don't think that argument is preserved. And there's also no evidence that these medical records were not accurate in the record below. And Dr. Baggerly, I think, in his testimony, definitely attested for what was done. It is our position that the trial court acted reasonably and had a sufficient evidentiary basis to make its decision. Again, there was an evidentiary hearing where it could gauge the trial courts, gauge the credibility. This case is virtually identical to the Morgan and the Ramey case, and we would ask this court to follow its own precedent and affirm. And by committing fraud on the court, Ms. Houston forfeited her right to a jury trial. Thank you.
Thank you.
As the court has pointed out, this required, I would suggest to the court, Judge Bray to make a weighing of what he believed or did not believe. In Jacob versus Henderson, this court has said that the standard that the lower court has in deciding this is if it would survive a motion for summary judgment, the court should deny a motion to dismiss for fraud on the court. So, in the light most favorable to Ms. Houston, this is a lady who got involved in a significant automobile accident. She believed that she had migraine headaches that she had suffered from. My records and brief reflects that in a deposition, which was extensive, long time, she described the headaches, indicating that sometimes the back of her neck would cause her to get headaches. She tells them about Dr. Bagley. She tells them that Dr. Bagley refers her out to other physicians for some other things. Those physicians are in the Suncoast Medical Clinic, which includes Dr. Clark. She tells them that she's had epidural steroid injections into her neck. But it's her testimony before the court with a high school education, never been in management, that she believed her problem were headaches, not this problem that occurred as a result of this automobile accident. Now, if that creates any material issue of fact, the court should not, in these situations, weigh and decide, I don't believe Ms. Houston, and I think she should have remembered these things. The court has to say, this is just absolutely blatantly false, and it's a scheme, which there's never really any proven of a scheme to prevent them from getting the records that they got. So under these circumstances, we don't believe, and we ask the court to reverse, remand, and give her a right for a jury to decide these issues.
Thank you, Mr. Wood. Thank you, counsel. The next case is Groneman versus Castillo at Tiburon Condominium.